Right, hello again. I'm here with Paul Lucas from SES. Hello, Paul. You well?
Morning, Peter. I'm well, thank you. Yourself?
Okay, thanks. Very well, very well. We're actually talking today about all the changes that were brought about to do with evictions and going to court, and this is all brought about by changes to something called the practice direction. And I'm sure you'll tell me if I get this wrong, but basically, this is what the courts are told that they must follow. So they must do it according to this practice, and they've got different numbers. And there was a practice direction 51Z, which came in earlier on this year, but Paul's going to talk about that. Just to make it clear to you that that a lot of people thought that they couldn't do eviction notices at all. Yes, you can still do eviction notices. All that's happened is that you couldn't actually go to court with them. So, Paul, do you want to explain what's going on now with, well, the practice directions and the lifting, etc., etc.? So,
Yes, of course, Peter. So as you mentioned, Practice Direction 51Z effectively stayed all possession claims at the beginning of the lockdown. It was due to expire in June, but it was extended until the 23rd of August. So that means all claims were stayed until that date, all possession claims. The Rules Committee have now introduced Practice Direction 55C. That comes into force on the 23rd of August, and that addresses how possession claims will be dealt with by the courts moving forward. Now, it addresses claims in two categories. Those claims that were issued and stayed before the 3rd of August, and those claims that have been issued after the 3rd of August and stayed, or any new claims. So I think it's probably helpful to just address those two separately.
okay.
In terms of any claims that were issued and stayed before the 3rd of August 2020, a party, and that's most likely going to be the landlord, will now need to file and serve something called a reactivation notice. It's a new document, it's unheard of before.
Yep.
Now that document must state that the party filing and serving the notice wishes for the case to be listed or relisted, as the case might be.
Yep.
And also what knowledge the landlord has about the pandemic's effect on the tenant and the tenant's dependents, if any.
Yep.
The notice must also include a rent account for the last 2 years, if the claim is based on rent arrears. And if any case management directions were made before the stay, the notice must enclose a copy of those directions together with new dates in a proposed draft order. Or if it's the case that no further directions are required, a statement to that effect, and that the existing hearing can be still heard. So that's the scenario where a case was listed before the stay in, say, September, October, but everybody's ready to still move forward with it.
Yeah.
And then finally, a statement about whether or not the claim is suitable to be heard by video or audio link, because as you can imagine, most hearings are being dealt with remotely at this point in time. Couple points to make. This doesn't apply, so the need to do a reactivation notice doesn't apply to enforceable possession orders. So those possession orders, they're either outright or were suspended that have been breached, and all you need to do is apply for a warrant. So you don't need to do a reactivation notice in that case, and it also doesn't apply to any appeal cases either. If the tenant doesn't agree with the proposed directions, if that's one of those cases, then they need to file and serve a notice in 14 days following your reactivation notice explaining why.
What notice do they have to serve?
So if it's a case where new directions are required and you've, as the landlord, have proposed what those directions should be, if the tenant doesn't agree with them, they simply need to do what's called a notice in response.
Yep.
Effectively their opposition to that, if they have any.
Okay. All right.
Um,
Before you go on, we've put together a draft reactivation notice, which hang on, which I will just briefly show you. So that's there. Let's just make it a bit bigger. So as you said, so that's what we're suggesting it could look like, and it's covering all the points that you said there, and things in yellow are matters that the claimant, who normally will be the landlord, as you said, will have to fill out. So that will be available on our website.
Yes, and that certainly covers all the scenarios, Peter. The difficulty with the reactivation notice is that there isn't a prescribed form.
No.
So really what you put together is ideal for iHouse members to use. It's a shame there isn't a prescribed notice, just because I'd like to see, or I'd like to hope that we can avoid any sort of technical arguments from tenants about what the notice should include. So prescribed notice would have helped, but I think the one you put together ticks all the boxes in the different scenarios. So
Okay.
I'd certainly recommend using it. Just on the point of these claims, if you weren't to file a reactivation notice, let's say you don't want to proceed with a claim at the moment, or the tenant is making payments and everything's fine, the claim will be stayed after the 29th of January 21. So what that means is the stay at the moment is lifted 23rd of August. If you don't do anything, it will be stayed again 29th of January. And if you wanted to recommence the claim after that point, you would need to apply to lift the stay.
And would you do a reactivation notice, or don't you know? Have they not said about that?
That's a good point. Not clear at the moment. It's simply saying you need to apply to lift the stay. It very much depend on whether that practice direction was still in force at that time, I suppose.
Okay, yeah. All right, okay.
So that's the situation with claims issued before the 3rd of August. For those claims that are issued after the 3rd of August and stayed, or that are now issued moving forward, you don't need to do a reactivation notice, but you do need to do a notice which states or demonstrates the landlord's compliance with the pre-action protocol. Now that's only going to apply to social landlords, so not particularly on point for iHouse members. But again, what knowledge the landlord has about the pandemic's effect on the tenant and any dependents.
The only thing I would say about the pre-action protocol is that the housing secretary was trying to bring that in for normal private landlords as well. So, but that seems to have died a death, doesn't it? So. That's
exactly right. It's a case of just watch this space. There's certainly talk about it, but they've got, I suppose, bigger things to deal with at the moment. So that notice, it's unnamed. It's just called a notice in the practice direction. It needs to be served on the tenant 14 days before the hearing. And then what's slightly ironic is that 2 copies should be brought to the hearing, which I'm not sure how you do that with there being no physical hearing, so I suggest you probably email it to the court in advance of the hearing.
Okay.
We then have accelerated possession claims. So again, with that claim form, you need to include a notice or a document explaining what knowledge the landlord has of the effects on the pandemic on the tenants and any dependents.
Okay. Right. Okay, so there's a lot to be done, isn't there? So
there is, yes. It's certainly increasing the workload for the landlords.
Yeah.
But a couple of points just to make on this, really. Reactivation notice doesn't need to include a statement of truth. In terms of the information about the effect the pandemic's had on the tenants and any dependents, it's simply a case of putting what knowledge the landlord has. There's no obligation to make inquiries, so at this point, simply not known would be sufficient if that is the case.
Yep.
There's certainly no need to go and investigate, as it were. Again, how the court's going to handle that information is interesting as well, because it certainly can't have any impact or effect on a claim based on mandatory grounds. So Section 21 or Ground 8, the court has to make a possession order if they're made out. So how the court's going to use that information, I'm not sure. It might be they consider it when deciding whether or not to make an extended possession order, so 14 days up to their maximum of 42 perhaps.
Yeah.
Might be it's something they have regard to if they're granting possession on discretionary grounds, so say grounds 10 and 11, for example.
Okay.
And then I think again, just to deal with how the courts are dealing with these claims, or how we think they're going to deal with them. Sadly, the headline is expect delays, I'm afraid. What we've seen is that the practice direction has also removed the eight-week period for listing the first hearing. So before the pandemic, when things were normal, as it were, a possession claim, when it was issued, had to be listed for a hearing within 8 weeks.
Right.
That's now being removed, which is indicative that the courts don't believe they're going to be able to adhere to that rule.
Yep.
And at the moment, all they're saying is that any hearing has to be, the parties have to be given 21 days notice of that hearing.
Right. Okay.
The other difficulty is,
as well, haven't they? They've been putting together. I know there's a court in Chichester which is handling an overflow for Worthing, and you've got a couple in London, haven't you? So
that's right. We've just seen different courts taking different approaches, which honestly hasn't been particularly helpful. We'd much prefer a consistent approach from the one county courts.
Yep.
Again, in terms of just listing these hearings, the argument is remote hearings are going to be appropriate for substantial possession caseloads, because technology, economics, and because really there isn't going to be a duty scheme for the tenants to make use of.
Right.
That said, the courts aren't going to be in a position where they accommodate the old practice of block listing for the foreseeable future, simply because social distancing won't be able to be maintained given the amount of people that would normally be in the courts on those particular lists.
Yep.
So again, it remains to be seen what they're going to do. I envisage it's going to be remote hearings with ample notice being given to tenants so they can go and get advice if they need to. But really, it's going to be a slow process before the courts really get up to any sort of speed with it.
Yeah, yeah, okay. And the current 8 weeks notice on the Section 8, Section 21?
Yes, there's still the requirement to give 3 months until the 20th of September.
Right.
Ironically, though, what would one do on the 19th? Do you wait to the 21st and then give 14 days, or do you send it on the 19th and give 3 months? So
yeah.
Really, there's an argument to say the closer you get to that date, you may as well wait until that extension's come to an end. Really, it goes back to.
Is it a case of that if the government don't renew it, it will automatically revert to the previous situation of 2 months' notice for 21? And
that's right. Yes.
Yeah.
I mean, again, there is the danger that there is, that is extended under the coronavirus.
But they would have to actually extend it, so
right, yes.
What happen? All right, okay. So I'm going to do a fact sheet for this, which will be available as well. So I'm not going to ask you to have a look at it, but just to basically go back over it to say that if you've issued a Section 8 or a Section 21 or both before August the 3rd this year, 2020, you'll have to serve the reactivation notice to reactivate it. If you've served the notice after August the 3rd, you won't need to do a reactivation notice, but you will need, in both cases, to advise the court whether if it's rent arrears, whether the rent arrears is due to the coronavirus. I mean, we've been saying to landlords for some time that if their arrears particularly goes back before March, which a lot do, and if it's nothing to do with coronavirus and they can prove that, they need to bring that in and that's absolute paramount, isn't it? So
Yes, that's true.
so well, it's going to be interesting stuff to see what you know what the courts make of all this, isn't it? So
It is, yes. Watch this space.
so are you expecting to be going back to court, or are you expecting me doing it by video? I mean, or do you just don't know?
We just don't know really. What we've seen is everything went remote to begin with.
Yeah.
I've seen certain courts that are now doing in-person hearings. I think Manchester did a while ago. I think Leicester did actually, ironically.
Right.
But
Yeah.
yeah, so it's really a case of just watch this space and see how the courts
Okay.
courts get on with it.
All right, well, Paul, thank you so much for that. It's been very much appreciated. I say I'll put the information up on the website. I have no doubts that when we put this out, we're going to get some questions on it. And unfortunately, quite often the question is going to be, we don't know. Just wait and see. But we're getting awfully close to August the 23rd now. Today's August the 17th, so August the 23rd is what? It's this.
It was Sunday, so Monday's today.
Monday of next week. In theory, we sort of get back to a little bit of normality, but unless Mr. Jenrick changes his mind yet again this week, but we hope he won't do. So, all right, Paul, so, thank you so much for that. It's very much appreciated. So, and we look forward to catching up with you again soon.
You're welcome. Thanks very much, Peter.
Thanks.